Hello, this is Paul Callahan from Taylor Wessing. Welcome to our latest EMEA General Counsel webinar. Today we're going to be looking at some changes in UK and French employment and privacy law, as well as looking at the increasing trend for employees, particularly in the UK, but across the whole of Europe, to try and to ask to work flexibly. Flexibly can mean shorter hours, or it can mean different places, or just any way that is different from the normal 40-hour a week or 38-hour a week if you're in France in the office. So to get us going on that, James Watkins is going to start discussing some of the legal issues as well as some of the cultural changes that we've seen recently in Europe.
Thanks, Paul. So, flexible working, clearly it's not just a UK trend, but it is a worldwide phenomenon now. There's been a lot of investment in technology and development in technology, which has brought about an increase in supporting the flexible working business model. And it's fair to say that we are dealing with an increased number of flexible working requests from our employer clients. So we thought it would be useful to actually have a recap of the flexible working legislation over here in the UK, highlight some of these trends, perhaps highlight a few practical tips on how to actually deal with them, and also mention a couple of employment tribunal cases that have come up recently in specific contexts where employees have made flexible working requests when they've returned from maternity leave. So one thing that is quite interesting as well is looking through a few employee surveys in recent times. Employees are really beginning to value flexible working as one of the top benefits really, and does rival some of those other fringe benefits in employment packages. It can also be seen by some employers perhaps as a way to motivate and retain top talent within organisations, given the increased importance that employees are attaching to this ability to work more autonomously and freely. So I thought it would be useful to first give a recap of the legislation over here in the UK. And I think one of the common misconceptions from employees is that they actually have a right to work flexibly, and that is incorrect. Under the legislation, you have the right to request to work flexibly. And as I say, that is often a ground of misunderstanding by employees. Employees do need to have 26 weeks of continuous service over here in the UK, and you do need to be an employee, so that would discount other categories such as agency workers. You can only make one request in a 12-month period as well as if you are an employee. As Paul's already mentioned, there are various forms of flexible working, and I think a lot of people think it might just be working from home, but in fact there are lots of different forms, such as changing working hours, perhaps working part-time, even job sharing as well with other employees doing a similar role. In terms of making a flexible working request, there are some prescribed there is a prescribed procedure for employees to do so, and I've listed there on the slide those requirements. So it does need to be in writing, it needs to be dated, you need to state as an employee that you are making an application under the flexible working legislation in the UK, and importantly also you need to specify the specific change that you're seeking to your working pattern, and also the date that you would like it to take effect, and also whether or not you have made any previous applications. Now moving on to how we actually respond to flexible working applications. The overriding requirement is for employers to deal with such requests in a reasonable manner. And I think you really, as an employer, need to show that you are very much engaging with the employee's request, and you would sit down at the time of having made the decision and talk to the employee about their request and whether or not it is viable for the business for that particular role at the particular time that the employee has requested it. As an employer, you do need to give a response to the request within 3 months of the request. You also need to cite any specific reasons in the event that you're refusing to give the request, and that really is a key requirement. One way that if you are unsure of whether or not a flexible working request might work out, you could look to offer a trial period, and this is something that we're seeing a lot of employers do. So it does go some way to mitigating against any allegation that you've not properly considered a flexible working request. You might give an employee 3 or 4 weeks or so to see if it works out, and then sort of suspend your decision until that point in time to see how it does map out. If you do successfully grant a flexible working request, you should, within 1 month of the changes taking effect, issue a written statement of changes to the employee's terms and conditions and have that all fully documented so it's clear what the new working pattern is. And one effect is that it is a permanent change to an employee's terms and conditions, so you cannot go back to your old terms and conditions without consent from the employer. If you're looking to refuse a request, it's fair to say that there is quite a lot of flexibility for employers to do so, and there are some common grounds that come up. There are 8 statutory reasons for refusing a flexible working request, and the common ones that we see that come up on a day-to-day basis are the detrimental impact it would have on the performance of the organisation if a particular employee was to work flexibly. And also, a key one is the inability to meet customer demand. So, for example, if you've got lots of sales employees who a key requirement of their role is actually to go out and meet potential customers and clients or existing customers and clients, having them work from home or perhaps at hours where they're not able to contact the customers and clients may not be something that is viable for your particular business. So those really are the common grounds that come up. There are a number of complaints that can be made, and I've tried to see by employees. The most common ones in relation to flexible working legislation are that the employer failed to deal with their request in a reasonable manner, and that's why I say it really is important to document all the conversations you have with employees, show to them that you really are engaging in their request, perhaps come up with some compromise solutions and really do explain, if you're not granting a request, why you're not doing so and what the business grounds are. You might also say, well, it's not possible at this time, but after the expiry of another 12 months, we can revisit it and we'd encourage you to do so. So it really will depend on the circumstances in play at the time. Also, sometimes employers fail to actually notify or respond to employees within the 3-month period, and they don't actually state one of the 8 grounds on why they haven't done so. So it's wise, of course, to do that. Compensation per se isn't that high for an employee if they have a successful flexible working claim. It's capped at 8 weeks' pay, and there is a cap of £479 per week. But I think the real value for employees is that they often look to link in indirect sex discrimination claims to flexible working requests, and that's where more value could be in such a claim. So there really is an importance, as I say, in dealing with each application on its merits and citing those reasons. Here I've just looked to list a few of the common employer pitfalls. Some of these I have already mentioned. So matters of good practice really are holding meetings with employees when you're considering the request, show that you've, show that you've considered the request, the reasons why you're granting it or not. Sometimes there can be issues as well raised by employees that the people that they've made the flexible working request to don't actually even understand as well as they should do the flexible working legislation. So it's important that the people dealing with the request are properly trained and up to speed with where the legislation is at. And one other issue that we had come up recently was that sometimes flexible working requests from people who aren't even eligible for it are just completely ignored, and it would be a matter of good practice to deal with each flexible working request, whoever makes it, and deal with that succinctly. As I said at the beginning, there have been a couple of recent tribunal cases over here in the UK that have been quite interesting. Fortunately, they've come down on the employer side, and they relate to 2 particular incidents, separate cases where employees who have returned from a period of maternity leave have made flexible working requests. The first case involved an employee who was involved in worked in a design business, and she wanted to have a flexible working regime where she would actually work from home for 4 days a week and do most of her work after 6 p.m. in the evening. A fundamental part of her role was to actually meet with other designers in certain studios around London. The employer, probably clear to see as well, the employer refused the flexible working request on the fact that such a key component of her role was actually meeting up with other designers. So her working from home really wouldn't have worked for the organisation, and they declined that request. she went to the tribunal and she said there'd been a breach of the flexible working legislation, and she also brought an indirect sex discrimination claim as well, but the tribunal did dismiss all of these claims, saying it was fine to refuse the flexible working request on those grounds, because it just wouldn't have worked for the business. And just very quickly as well, there was another case involving a PA in a small investment banking firm in London, and she made a flexible working request after she returned from maternity leave. She just had twins, and she wanted to work. She only wanted to work 3 days per week, one in the office, one day as a home worker, and then one day she wouldn't work. Again, the employer refused this, saying that it was such a small investment banking team that would have a disproportionate effect on the rest of the team if she wasn't there, and they had a legitimate aim of ensuring that they had proper PA efficient support during the week, and for her to be away really would have detracted from that and not provided proper service to all of their clients. So again, that was denied on those grounds. She brought a claim. Again, she brought in an indirect sex discrimination claim as well, but all of the claims that she brought were dismissed in their entirety. So there are a couple of cases there, certainly within the maternity leave context, that have fallen in favour of employers. But I think the one thing that was probably highlighted in terms of flexible working is that, of course, we are seeing it more and more, but you really should analyse each request on its merits, and you should properly engage in the specific request being made. You can perhaps use previous requests as precedent if it relates to a similar employee in a similar role, but you really should look at whether or not it can be something that can be given to employees at that particular point in time. So that's just a bit on flexible working. I'm now going to hand over to my colleague Colin, who's going to talk about some very interesting developments in relation to modern slavery.
Thank you, James. As James mentioned, I'm going to speak now just about the Modern Slavery Act 2015 and briefly summarise why it's relevant, what it means for organisations who are doing business in the UK. And so to start, just in terms of what it actually is, the Act is actually a very wide-ranging piece of legislation aimed at measures to actually deal with modern slavery in the UK. But the key part for us today is the requirement for certain businesses to produce an annual statement setting out the steps they've taken to ensure that modern slavery plays no part in their business or their supply chain. And there are a number of key reasons why the legislation has been introduced, with details on the slide there. But really, it's to make organisations who are doing business in the UK think really carefully about how the materials they're using, the labour they're sourcing, where it all comes from before it actually gets to them. So, for example, in retail, who's actually supplying the raw materials that they're using, and what are the conditions for those who are actually involved in the manufacturing. And the intention is to try to make UK business, or businesses doing business in the UK, accountable to their customers and their consumers by making this whole process more transparent, and generally to drive up standards through consumer pressure. It's also aimed at increasing the strength of UK bargaining power, essentially trying to make doing business in the UK the gold standard, so showing it as some form of badge of honour for businesses who are doing work in the UK to show that they're complying with the requirements of this Act. So what do we actually mean by modern slavery? So the definition in the Act talks about slavery, servitude, forced or compulsory labour and human trafficking. This gets broken down into 4 different things. The first is working under threat of a penalty. The second is those coerced to work where there's an impossibility of changing their conditions. The third is in relation to the deprivation of freedom. And the fourth in relation to those who are transported with a view to exploitation. Whilst obviously businesses would generally balk at the idea that any of this could actually happen within their own business or supply chain, the key message is then dispelling the myth that it couldn't happen here, that sort of mentality that actually this is somebody else's problem, and to get organisations doing business in the UK to really think about this in the context of what's applied to them. Because the statistics are actually quite shocking. In the UK, the figures back in 2014 suggested that between 10 and 13,000 people in the UK were in some form of modern slavery. And then when that's expanded globally, the current estimate puts that number at nearly 46 million. And this is very high on the political agenda in the UK. It was introduced, the Modern Slavery Act, by Theresa May whilst she was actually Home Secretary. So since she's now Prime Minister, she's taken this really to task. And she's been very vocal about it with announcements back in July and October vowing to defeat the evil of modern slavery and pledging to put Britain at the forefront of the fight. So why is this really relevant for your businesses? And really you can view it in both a positive and a negative way. The positive is really to see it as an opportunity for your business to make it actually harder for any form of modern slavery to occur anywhere within your business or supply chains, but also to make sure that your own suppliers meet the same standards that you've set, and to outwardly display to the public, including your customers and consumers, that you believe this is an important issue and set out the steps you've been taking. But there's also the harder edge to it and the negative side of it, which is that there are sanctions for non-compliance. So for those who are caught by the requirements of the Act, if you don't comply, you can be obliged by the Secretary of State through an injunction to produce a statement, and that if you don't, it would be a contempt of court, which could lead to an unlimited fine. But in reality, those who are actually faced with an injunction would simply take steps, I'm sure, to comply before formal action is required. So the really harder element to it is actually on the impact on your reputation and your brand. A brand has never been more important, and so a successful reputation can be undone very quickly. There are a few examples on the slide there of a few cases which have been reported in the paper of examples of, for example, Nestle being reported for slavery in Thailand. Companies such as McDonald's, Tesco, Asda, M&S, Sainsbury's using eggs from trafficked Lithuanians. Refugee children being used in the manufacturing of clothes for M&S was something recent in a Panorama documentary. And all of this really shows the importance of actually assessing your supply chain, identifying what the risk level is, setting the standards that you require, and making sure that there are processes in place to weed out malpractice. And that's effectively what the intention behind the Act is. And so who actually needs to produce a statement? The legal test is fourfold. The first is that you have to be a commercial organisation. The second, carrying on business or any part of your business in the UK, and that's regardless of where your business is actually based. So simply having any form of footprint in the UK is likely to be enough. You need to be supplying goods and services, and also have a global turnover of over 36 million. Now that's one of the key requirements, and it's £36 million. And effectively that includes any revenue generated by subsidiary organisations as well. And to make life easier, we have developed a very quick and easy and a free assessment tool. There's a link to it on the slide, but you can also get to it by searching online for TW Assessment Tool. And it is essentially a quick and easy way of finding out whether or not your business is going to be caught by the requirement to produce this type of statement. But even if your business is not caught, the merits of taking some steps to ensure that there's no modern slavery in any part of your business is well worth taking for all the reasons that I've mentioned, including reputational issues. And we've actually seen a number of organisations coming to us now who themselves are suppliers and have been asked to confirm the steps they've been taking by the organisations they are supplying to say what steps they have been taking to eliminate or make sure that there is no form of modern slavery in their business. So it really is very relevant for every business to think about. So in terms of what a statement should cover, to be legally compliant, it needs to do one of two things: either outline the steps that have been taken, or simply state that none have been taken. We yet to see anybody bold enough to say that no steps have been taken, and I'm sure that that's going to be unlikely. So most people will usually say something. And the government guidance on this suggests that information contained in a statement should cover the structure of the business and supply chain, the sort of policies that are in place to try and make sure that there is no form of modern slavery in the business or supply chain, any due diligence processes that have been undertaken in relation to where you receive your supplies, any risk assessment you've conducted in terms of where the higher risk areas are, the effectiveness of the steps that you've taken, and any training that has been offered to those who are particularly involved, perhaps in the procurement of services for you. The Act essentially expects that it's going to be approved by the highest level of management within the organisation and signed off by a specified individual. For most companies, it's going to be a statutory director. So we've covered who needs to produce a statement, what it needs to include. The next question is when it actually needs to be made. And the trigger date is the first financial year end date on or after the 36th of March 2016. So that's the date that sets the clock running, and then you have 6 months effectively from that date when you should be producing a statement. And it's important to mention that this is an annual obligation, so it must be repeated every year. So the idea is that businesses will review and update what they've done on each occasion. Lastly, from me, in terms of where the statement needs to go, there are specific rules about where it needs to appear. The main position is that it needs to be on a prominent place on your homepage. It should be the most appropriate website for the business that is being carried out in the UK. It needs to be visible, and it needs to be specifically marked as a Modern Slavery Act transparency statement. And the key message really from all of this is that the intention is that this becomes part and parcel of doing business in the UK, and it is likely to be actively policed. So I think in terms of what to take away, check if you need to comply by carrying out the assessment on the free tool, and check if you do need to comply, then when you need to do it, and then whether or not you're caught by the requirements of the Act, it is worth taking steps to identify early whether or not there are any potential issues within your supply chain, introduce potentially some policies and contractual wording that can help you to protect against any rogue suppliers, and also see this not only as a compliance exercise, but as a selling point really, and a way of sending a positive message to your customer and consumer base. So that's all from me. I'm going to pass over now to my colleague Charlie, who's going to talk about immigration.
Hello everybody, my name is Charlie Pring. I'm going to give you a quick update on UK immigration. Starting with Brexit, which has dominated our agenda for the last few months, and access to European workers, European talent. Immigration was a defining issue in the Brexit vote in June, and it continues to be a high-profile issue with a tension between business and EU citizens that want to try and retain the system that we have at the moment, which is free movement across the UK and Europe, and those that want to control immigration and have a system of restriction on the numbers and the type of foreign workers that can come to the UK. Now, the good news from a business point of view is that there are no immediate changes to the rules, so the UK remains in the EU and will stay that will stay that way until at least the first quarter of 2019, possibly later, depending on some legal challenges to the government. But until spring of 2019, you can continue to employ any European workers without needing to think about visas or immigration. And the same is true for any British citizens that are working in other European countries. And during that exit period, while we negotiate ourselves out of the European Union, European citizens can still relocate to the UK from overseas, again without needing to worry about any sort of immigration or registration permissions. The eligibility rules for EU workers already in the UK, and particularly for those people that have arrived in the UK after the vote in June, does remain to be seen. That will be a matter of negotiation between the UK government and the European Union. The UK government doesn't want to guarantee the status of EU workers and EU citizens yet, because it wants to agree reciprocal rights for the 2 million or so British citizens that are currently living in the rest of the European Union. We expect there to be some form of work permit scheme or registration scheme for EU citizens that arrive to the UK after the formal exit date. All sorts of suggestions have been put forward. Nothing has been agreed. Possibly there would be a quota system, so perhaps a cap on a per sector basis. So for example, might be a set number of agricultural visas that would be approved for a particular year. That really does just remain to be seen. One interesting suggestion that has been in the media recently is a potential for a London-only visa. It's something the Mayor of London is looking at the moment, whereby because of the very diverse workforce in London, there will be a particular scheme allowing workers in London to get their own visas. I mean, we think that while it would be great for those businesses in London, in reality it will be very difficult to persuade the government to agree to it because of concerns that it will be, firstly, overly complicated, secondly, difficult to monitor for those London-based employees that work out of multiple UK offices or that travel extensively across the UK. And thirdly, that it will be a hard sell politically because other regions of the UK will want their own system, and because there is a drive to try and rebalance the economy and move workers away from London, or at least not attract them to London like a London visa would probably do. So what about for those EU citizens who are currently in the UK and how to safeguard their status? We receive a lot of queries about from concerned citizens and businesses about how to protect their status. They're worried about what might happen, and there are some optional steps that UK employers can take proactively to reassure their workforce, especially if we end up with what people are calling a hard Brexit, so one that has more restrictions around workers and visas. So we're helping many companies at the moment to proactively support their EU staff in the UK. So it might be, for example, helping them with a legal advice surgery. It might be helping them with the costs of applications to try and safeguard their status. It is worth looking at your workforce to see what is the composition of British workers, European workers and non-European workers to see how important that might be to help with their concerns. So what are the applications that employees can make? Well, the first one is permanent residence. So the government think that by 2019, about 85% of European citizens in the UK will have reached 5 years stay in the UK, which enables them under European law to apply for permanent residence, which means that there would then be an indefinite stay. There would be no way for them to be forced to leave when the new rules are announced. It's a very low government fee. It's only £65 per person. There is a new online system to avoid people having to surrender their passports when they apply. And the other reason why it can be important is that for anyone wanting British citizenship, getting permanent residence first is a mandatory stepping stone to achieving that British passport. For EU workers who have been in the UK less than 5 years, you can still apply for a registration certificate, which is effectively registering your right under EU law to be in the UK, which should help or may help to put that person in a stronger position when the new rules are announced. Processing times are starting to slow down after the Brexit vote. There's been a spike in the number of applications, so it is better to get on with that and apply now rather than wait for the rules whenever they are announced. So with all with Brexit sort of dominating the agenda, it's easy to forget that there are new rules as well for non-European visas. So we'll just have a quick look at the latest developments. There are some new visa rules for non-European work visas from 24th of November. So for Tier 2 intra-company transfers, or ICT, the skills transfer route, which is a 6-month temporary visa, is going to close. The short-term route, which is for assignments of up to 1 year, the minimum salary is going to increase to £30,000 per year, and that will go up to £41,500 sterling from April next year. In Tier 2 General, which is the category for external hires, that minimum salary threshold is going to rise to £25,000 per year and £30,000 from next April. In reality, many of the US businesses we work with, that's not so much of a problem, but it can be more of a concern for SMEs and startups where those minimum salaries do start to affect the business. There's also going to be a removal of the current grace period for overstayers, for people who go beyond their visa period accidentally, and so that makes it even more important to make sure that companies are organised about monitoring visa end dates and renewals where needed. We expect shortly a new NHS charge for Tier 2 intra-company transfer visas to bring it in line with Tier 2 General. That's a £200 per year of the visa upfront charge as a contribution to the NHS. And then from April next year, there will be a new immigration skills charge for all Tier 2 visas, which will be up to £1,000 per year of the visa for large companies. So it will really impact on the cost of arranging visas. So what can you do now? Well, think about whether you can accelerate any new hires before next April, particularly to avoid the immigration skills charge. Think about clawback of government fees in the employment relationship, in the employment contract. That does need an agreed term with the employee. At the beginning of next year, all sponsors or Tier 2 sponsors will need to request how many visas they want for the next year. That's nothing new, but it's something to ensure happens. And then be aware that there's a greater emphasis on compliance at the moment, with Home Office checking on employers to make sure they're doing the right checks before employment, and also on sponsors to make sure that they're complying with their various duties. So let me hand over now to Sian Skelton to give you the latest developments on data privacy.
Thank you, Charlie. Good afternoon, everybody. So I thought I'd just use this time that we have together today to talk about and give you a brief update on EU privacy matters, which are applying to all businesses here in Europe. The two areas I thought I would touch on are Privacy Shield and the GDPR regulations, which are due to come in May 2018. So if we turn first to Privacy Shield, as you may be aware, transfer of personal data outside of the EU is prohibited under EU data protection legislation. That's the case unless the transfer is undertaken in a compliant manner. US businesses receiving personal data from Europe were previously able to rely on the FTC-run Safe Harbour scheme. This meant that once you were registered, EU companies could rely on this registration as compliance for the transfer of personal data to the USA. So it became a tick box. Once you could check that the organisation was registered on the Safe Harbour list, you knew that they were compliant, and therefore you were free to transfer your personal data from Europe to the USA. In October 2015, following a decision of the European Court of Justice, it was decided that the Safe Harbour mechanism was no longer a compliant mechanism. And basically, overnight, the scheme fell over. And subsequently, EU and US businesses have returned to relying on the slightly awkward approach of using model clauses to govern the transfer of data. Model clauses are a predetermined and pre-approved set of clauses which can't be negotiated or altered, and they're entered into between the data exporter, that's the European business that's exporting the data to the US, and the data importer, the US business receiving the information, personal data from Europe. Although steps have been taken to try and make entry into these contracts as smooth as possible, it's still not an entirely smooth process. And it adds to your sales process, and it adds to the number of contracts and documents that need to be signed at the point of the sale. In August 2016, applications for the new Privacy Shield opened. This scheme, the Privacy Shield, is a replacement for Safe Harbour, and it allows EU companies to transfer personal data to registered US companies, safe in the knowledge that they're complying with the obligations to only transfer personal data outside of the EU in accordance with an improved and adequate mechanism. Privacy Shield is an FTC and Department for Transport run scheme, which, like Safe Harbour, requires US companies to self-certify that they're operating in accordance with Privacy Shield principles. There are 7 principles with which the company must comply, and undertaking the certification process will require companies to review their practices and processes, ensuring that they've made the necessary amendments to their privacy notices, that they have provided the individuals about whose personal data is being transferred access to an independent dispute recourse mechanism, so that if disputes are not resolved internally between the US company and the individual, the individual can take the matter further and try to resolve it by way of a third-party provider. And ensure that also that sub-processors, so anybody that the US company is using to also process the data on behalf of the EU company, are also complying with the various provisions and principles of the Privacy Shield. It's to be noted that the privacy notice, or we call it here in the UK privacy policy, is something that's made publicly available. It's it's submitted as part of the application process to the FTC. They run through the privacy notice, ensuring that it contains all the relevant information, and then the expectation is that that notice is made available on all relevant websites that the business may be operating. Our recommendation when looking at Privacy Shield is that the actual relevant compliance work is undertaken prior to undertaking the registration itself, as the FTC or the Department for Transport, whichever is applicable to the US business, will have the right of audit at any time to ensure that there is compliance. Having just returned from a trip to the Valley last week, it was very evident that a number of US companies are applying for the Privacy Shield, and indeed from talking to the companies, there is a backlog in the FTC and Department for Transport registration process of up to several hundred registrations, which are still being processed at the moment, with more being added every day. To date, there are over 500 US companies that have managed to successfully register, which, given that the applications opened in August, is pretty good going, and shows how seriously many US companies are taking this as an approach to being able to move successfully away from the model clauses again, back to a much easier to manage and a much more streamlined and efficient system in respect of Privacy Shield. The other thing I wanted to touch on this afternoon was GDPR, the Global Data Protection Regulation. This regulation has been passed by the European Commission and will come into force across Europe in May 2018. The effect of the regulation will be, as far as possible, to harmonise the data protection legislation across the whole of the EU. The new regulation will affect all EU businesses and require that they make amendments to their business processes and to the relevant documentation that they need to enter into. Due to the Brexit vote, which obviously occurred earlier this year, there's been some debate as to whether the UK would actually continue to implement the regulation. I'm pleased to report that in the last few weeks we've had confirmation from the Government Minister, as well as the Information Commissioner herself, that the UK will continue with the implementation of the GDPR. While this is good news for UK businesses, especially those who are operating across Europe, it does mean that all businesses now need to start planning for the changes that they need to make to their businesses and their business processes to ensure that they are compliant. If you'd like any further information on Privacy Shield or GDPR, please do not hesitate to get in touch. And now we're just finally going to turn to my colleague Stephanie, who's going to be talking about some French law issues.
So there's been a couple of recent developments in France which you may or may not have been aware of, given the number of riots that have been taking place. Earlier this year, the French government put a bill before Parliament proposing key reforms. In late July, it finally was adopted and almost immediately got sent to the Constitutional Court by a good number of senators, and it was finally adopted actually in late August. The new law makes a number of changes to the French employment landscape with the intention of offering greater flexibility and power to employers, the government's reasoning being that this is in a bid to tackle France's rate of unemployment. I'm going to pick out a couple of the key things, although there are other changes it made. The changes are quite far-reaching. One of the main changes is to the collective bargaining arrangements in France. Going forward, company-wide CBAs can take precedence over sector-wide CBAs or branch CBAs in certain areas. This isn't a new thing, but it is new in terms of where it's going to be applying, because it's looking at working time. Some of the big things that it's going to be affecting is payment of overtime, the maximum number of daily hours that can be worked, which can now be increased by a company agreement from 12 to 12 hours instead of 10 hours, and the number of weekly hours, again, currently 44 is a maximum, and it can now, going forward, be set to 46 hours. It's a change not only in the way in which CBAs are orchestrated and negotiated, but it's also a change to the way in which the precedence is taken between company-wide CBAs and sector-wide CBAs. Previously, employees would have been entitled to the highest level of protection or the greatest rights. This is effectively a reverse of that, whereby if the company-wide CBA is less advantageous for employees, it will still be the agreement that will take precedence. One of the other key changes that's coming in as well is looking at redundancies and dismissals for economic reasons. New law is intended to give greater clarity in this area, including a new definition of redundancy and to deal with the transfer of companies during redundancies. There have been criticisms of the proposal to fix the definition of economic difficulties, which is one of the tests. And the idea being that if you fix a definition, it makes it more rigid and a bit more of a problem for employees. The new law effectively is bringing in two new grounds for redundancy, one of which is company's reorganisation where it's necessary to safeguard its competitiveness, and the other is the termination of companies' activities. This is arguably mirroring current case law, but it's just putting it into statute. The intention of the changes is to frame the discretion of judges when dealing with these matters and to try and reduce the litigation uncertainty, particularly for businesses and the costs around that. The change takes into account the duration of the decrease in orders or turnover in relation to this economic difficulties test, and also the size of the company in question. It's staggered. The geographical limit remains unchanged. The government did attempt to try and change this. It's not going anywhere at the moment. The trade unions in particular were pretty resistant to this. One of the other key changes in this area is the ability to make employees redundant before a business transfer. Ordinarily, on a business transfer, employment contracts would automatically transfer from the current owner or employer, the transferor, to the new owner or employer. And case law generally implies that redundancies made immediately prior to a transfer would be void and deemed to have no effect. The Labour law is making a change to this, and where a proposed redundancy includes a site closure to avoid closure of another site or to safeguard employment of other employees, the automatic transfer rules won't prevail, and the transferor can effectively dismiss employees by reason of redundancy. The exception is only going to apply to companies with more than 1,000 employees, or those with an obligation to impose a particular training threshold. But in effect, the benefits of automatic transfer of employment will only apply to those who have not been dismissed as at the date of transfer. There are separate obligations to look at potential transferees prior to the implementation. Those haven't gone anywhere, but it should make it easier, in theory, around redundancies and transfer of businesses. One of the other big changes is this right to disconnect, which has been picked up in the press, and you may have seen comments around it. It was introduced apparently to combat the risk of rest breaks being in jeopardy in order to ensure that people were taking their rest breaks, and also there was a balance between personal and domestic life. It's going to apply to a lot of people, companies with 50 or more employees and those with less than 50, but who are subject to flat rate pay agreements. The right to disconnect has to be negotiated with trade union representatives, but it leaves greater freedom around what the agreement's content and what the measures adopted have to be. The law doesn't require that employers have to take concrete measures to implement the right to disconnect, but it means they're free to do so if they wish to. So some larger companies have taken steps as an automatic server shutdown outside working hours. The actual obligation is simply to take actions to educate and raise staff awareness about the right to disconnect, and that can include things such as footers at the bottom of emails or advising employees to only email where necessary. The Labour law also provides for an establishment of a committee of experts and practitioners who will be responsible for proposing a new labour code with the government within 2 years, so expect to see further changes in this area. Just quickly as a flag, Uber and platform companies have been in the press recently, and it's the same in France as well. There's been a recent couple of cases dealing with this issue, which have come down, interestingly, at the moment, with an individual who tried to claim that he was an employee working in a similar way to Uber, and the courts have actually said it's a commercial issue and should be dealt with by the commercial courts. But this is a decision that's under review. It's caused quite a lot of controversy in France at the moment, and we're not expecting that to be a decision that is not contested or echoed around France consistently. Finally, just to flag an additional case of interest that's come up in France. The recent case around spying an employee activity and what you can do where there's an issue or you suspect that an employee is behaving inappropriately. In the case, an employer suspected their employee of working from home on other matters, doing other things, whilst he was supposed to be working for the French company. Deemed this was an issue of unfair competition, so they engaged a private detective to confirm their concerns. And the French Supreme Court ruled that the employer couldn't rely on the reports by the private detective, even though it showed that they were entirely right in their suspicions, The lower court should have rejected the application because the evidence was deemed to be unlawfully obtained. That's engaging a private detective was unlawfully obtaining evidence. And this was a breach of the employee's privacy and couldn't be justified, however legitimate the employer's concerns were. And on that note, I'm going to hand back to Paul.
Well, thank you. I hope you found that useful. It was, as you'll have appreciated, it was very wide-ranging, covering privacy in the UK and France, the Modern Slavery Act, immigration, as well as trends in flexible working. We have had some questions through, but because we've run out of time, we'll reply offline. And needless to say, anybody else who does have questions, feel free to email the speakers. The very last slide does have all of the speakers' details and email addresses, and needless to say, feel free to contact any of us. So thank you again for joining us. In 2 or 3 months' time, we will have our next EMEA General Counsel update, and we'll let you know about any changes in the run-up, any changes that take place between then and between now and then. So happy holidays. I hope you're somewhere where it won't be too cold over the winter period, and I look forward to speaking to you then. Bye-bye.